Protective Services real quick. Because we got a lot of people out there who have been having trouble with Child Protective Services. I mean, Child Protective Services, I really didn't know that Child Protective Services was as, a bigger problem. I had a lady here in California, her name is Dr. Shirley Moore. She has a video on YouTube called the Judge's Slush Fund. And what this lady has done is she found out that the courts are actually private entities, that the EIN number that they are using is not a real EIN number. They're circumventing filing taxes with the IRS and all types of stuff she uncovered. A very interesting video. People who get a chance, they should watch it on YouTube. But she also discovered a lot of fraud that they were doing and had a whole lot of Child Protective Services cases overturned. Can you give us a little insight on your perspective, how you would handle a Child Protective Service case? Because a lot of people are having, people, they take their child to the doctor. Next thing you know, the doctor says, oh, something's wrong with this child. Next thing you know, they come and swoop up the child to try to get the mother to testify against the father. Which one of y'all beating the hell out of this child and everything? No one submits an affidavit. The doctor at the hospital, he didn't submit an affidavit. Nobody submits an affidavit. I know that those issues are really moot and they're not germane to what's really going on. This is a commercial process. What are we looking at right here, and how do we go about handling that?
Well, I look at it like this. You have to understand, most people can't grasp this, but it's like I said before, all property, all insurance, all mortgage, all land, and all people are the express property of the United States of America. This is where they get their authority to come and grab your children. Unless you have a UCC filed on your property list, you list all of your children. I got on mine, I got my daughter listed and my 4 grandchildren listed with their birth certificates and their Social Security numbers. So when I file this, I have a preferred, perfected UCC lien, which is legal in any state in the union, and it specifically says whoever files first has the priority claim. Now, how many courts have a UCC filed on your children? How many protective services have a UCC filed on your children? If you file the UCC and you claim them on your property list as your private property, guess what? You have a preferred, perfected priority lien, and that means first in time, first in line to collect. So if you have to go to court, you take that document down there, certified from the Secretary of State, say, look, here's my children listed on my preferred priority perfected lien. Do you have a lien? Do you have a claim higher than my claim? If so, produce it. I have a $1 billion lien against all of my children, against all of my property. So if you don't have a priority perfected lien against my children, then you're trespassing on my private property in an amount of $1 billion.
Okay,
and you can legally file charges on a $1 billion trespass fee for them taking your children if you have it filed under UCC.
Okay, well, wait a minute, then. Let's talk about it, because I'm familiar with everything that you're saying. I've been doing this a while, too, and let me just say this. These people have developed, in my opinion, very skillful ways of circumventing recognizing your claim. Either they won't let you into court, they won't let you speak when you get in court. In some cases, you may even be arrested, and, they just hold you in jail. Not, tell your people that, you're, he's going to go to court, then I'm going to court, or whatever. There are a lot of other, circumstances that happen to people. Because I've been doing this a while. I've been dealing with these courts for a while, and when I've learned about them, and you're absolutely correct, when I gave them a certified copy of my UCC-1, that seemed like that made the judge very, very nervous. Very, very nervous in that. And when I did did something like that. But there was all this thing about me being able to come in and present this to the judge. A lot of times I would have an attorney or a public defender, and a lot of times they don't want to do it. But in all the paperwork that I see, you always have to reference this UCC-1 filing that demonstrates that you have a preferred claim against all of your property that you just said. But what about these situations where, hey, I'm not about to let you come in here with all of that. You're not even going to get a chance to speak. Is there an enforcement process that you recognize, or you just never had to even deal with that?
Well, the one time that I was in court for a situation like that, I just looked the judge in the eye and I said, look, Judge, you have enough money in your escrow account to cover the trespassing fees that you're going to incur for trespassing on my private property. The judge knew immediately what I was talking about. What I just told that judge was, is your bond big enough to cover the trespassing fees that you're incurring for trespassing on my private property? Now, if the judge has got any sense at all, he's going to slam the hammer down, say, case dismissed, take your children and get the hell out of here and don't come back. Now, you may have a judge that thinks that he knows better and that he can adjudicate against the UCC, but don't worry about that. Whatever he rules, just appeal it to a federal court, a federal district court. All judges in the federal courts understand the UCC. Courts, the lower courts, some judges do, some judges don't. They act like they don't, but they all do, but they want to act ignorant. If you're in a court situation where they just ignore the UCC, then immediately appeal it to a federal district court because they all understand it is federal district court.
Okay, now, are you appealing it or removing it to a federal district court? Because, there is
remove it to a federal district court.
Yeah, remove it. Yeah, you're going to remove it.
I don't go to court, so I don't even worry about dealing with that kind of stuff. I go to court, but I go there to sit and listen to see what's going on so that I can understand how the court system works. But as far as me going to court for any kind of reason, it's through paperwork and paperwork only. I had a young lady in Houston that had a $58,000 credit card debt. And she asked me if I could help her. And I did the paperwork, and it took 6 months of solid paperwork, bickering back and forth with the court. But when I finally got it all said and done, they dismissed the case, wiped the credit, and they're not bugging her anymore about it.
Okay, well, let's talk about in a criminal matter. You say you wouldn't go to court. Now, I've read a lot of stuff where they tell people don't go to court, bring the birth certificate in the court, drop it in the well of the court, tell them here's the defendant. I've even did that myself in some past. I did what's called a surrender of the defendant, where I actually submit to the court the birth certificate, a certified copy of the birth certificate to the court, all these numerous things. Because I'm in agreement with you. I don't think we have no business going in those courts for any reason whatsoever. Because, evidence has shown you don't win, when you make an appearance in any of their courts. You should, if you're going to handle it privately, there should be no reason to go to court. You just do everything through the mail on the private side and correspond with the judges privately. But what do you do? Now, I've read a Gene Keating transcript and a prison treatise where there were some people discussing that they did this to get off probation, and they said there was a warrant issued, but it was not a warrant for an arrest. That a warrant is like a check, and they had their police buddy check it out, and they said, well, yeah, this is some kind of warrant, but it's not to arrest you. It's a particular other kind of warrant after they submitted to their probation officer these negotiable instruments, because all probation is just, they're just debt collectors as well, too. So what do you do in a situation when you get a warrant for your arrest issue?
Well, what I did, I turned in a probate bond, and I sent it directly to the judge. And I don't ask, I don't request. I ordered the judge to pull the warrant and seal the case, because what he did, he trespassing on my private estate. He's got no authority whatsoever. No, I didn't authorize him to step onto my property and do anything. He's just taking it upon himself under presumption and assumption that he's got the authority to do so. So I send him a probate bond, and I order him to pull the warrant and seal the case. I also instruct him that if for any reason that my name comes up on any officer's computer when he pulls me over and there is a warrant in there, that he will be charged $1 million fine. Because I have a copyright trademark on my name, and I told him to pull the warrant. That means to take it out of the database. Get rid of it. Totally.
Now you said something very interesting right there, the copyright of the name. So you do suggest that we copyright our names, and what is the procedure for that? You know, I'm familiar with the procedure of copyright. I had a sheriff one time, I got arrested. I didn't really get arrested, but they pulled me out of court and pulled me in the back. And the sheriff came to me, and he asked me, he said, first thing out of his name, he said, you know, sir, I'm a public servant. I just want to know, is your name copyrighted? He said this to me, and I couldn't believe it. My mouth hit the floor. But I was by myself. You know, they had me in a cell, and they were around me. But they were worried about whether, because I just made this big stink in court. You know, the judge commanded me to sit down, and I'm like, man, you don't tell me to sit down, man. What's wrong with you? And I got into a verbal altercation with this court, with this judge in court, and they then took me to the back. So they're already thinking, okay, this guy must be some sort of sovereign or something. But I was in a suit. I was dressed real nice. I spoke very eloquently. And he came in, he asked me, he says, your name copyrighted. That's the first thing he asked me. What's the deal with this copyright of the name?
Well, back at the end of your name, you put a circle with a C in it. That means your name is copyrighted. And you stipulate in the copyright contract that any use of your name without your written express permission is whatever amount of fine you want to put on that, because that is your signature. That is your private property. So I put in my copyright trademark that if anybody uses my name without my permission, it's a $20,000 fine. If they take my fingerprints or toe prints, it's $1,000 per print. If they take my picture, it's $20,000 per picture. What do they do when they arrest you? They take you down, they slam you in the thing, they fingerprint you, they take your picture, and blah, blah, blah. That's a $50,000 total fine. And when I get stopped by an officer on the side of the road, I show them that I have a copyright trademark. And I say, do you have enough money in your back pocket to cover the fees that's going to cost you for taking me to jail? And if not, you need to go back and talk to your supervisor, because I personally will sue you. Not the police department, but you, because you're working for a private corporation, you're working in your private capacity, and I will sue you and own everything you got if you take me to jail.
Yeah, I like that. Now, let's talk about that real quick. They are operating under this thing where they have immunity as long as they are operating within the ambit of delegated authority, meaning that police officer is going to say, hey, look, I follow the rules of the state legislature. They dictate that, hey, you got a license plate on this car, you got a driver's license, you have all these things. The operational presumption is that you are operating in commerce. We have the right to regulate commerce.
Right. And
what do you think about that?
A lot of people don't understand the laws. They don't even read the laws. But where I live in a big subdivision on the county line, and I live right on the county line, so it's right between two different counties. Well, the only way into the subdivision is through the other county that I don't live in. So these county sheriffs, they come out there and they come inside the subdivision. They come down to the school stop button, they sit there, and they pull people over and write them tickets for all kinds of things. If you look in the law specifically in Texas says that no constable, no sheriff can leave the highway except in pursuit of a suspect. So if he's in the subdivision writing tickets, he's breaking the law. And everything he does is blowing noise. null and void, or whatever you want to call it. So people never read the law. They never find out that the guy ain't got no business in the subdivision to start with, unless he's actually been in pursuit of you on the highway, and you left the highway and came in the subdivision, and he's behind you with his red lights. Then he's got authority to stop you. Other than that, it got none.
So, well, you know, I wonder about that, though. Let me ask you a question. Couldn't these houses, because the state owns them, because we don't really own our houses either, and we have these mailboxes and addresses and everything, couldn't that be considered commercial, you know, within their commercial jurisdiction, though?
Well, it could be, but under the transportation code, it specifically says that the officer cannot leave the highway except in pursuit of suspects, unless you have called that officer for a specific reason to come into that subdivision. He's got no authority in there. Okay, because his job is to patrol. His job is to patrol the county roads and the county highways.
Right. Okay. Well, back to Child Protective Services real quick. Now, Child Protective Services, they have your kids. And for all of you who just listening, just saying, so we go in there, and they will release the kids once you let them know you have this priority claim. And these kids will be released back to the parents.
Well, I would, first of all, the Child Protective Service ain't going to know nothing about this. The judges will. But the people that work at the protection agency know. But I would go there and I would demand my children back. And if they say no, I would bring them a copy of the UCC and I would get their name and I would file charges against each and every solitary person that works there. Because they kidnapped your children. Kidnapping is a $10,000 fine or 10 years in prison or both. So why not use the law to your benefit? Why do you just sit back and say, oh, well, they took my children and I don't know how to get them back? Look, ain't nobody going to come to my house and take my children unless they get shot. Because I ain't going to put up with it. I got signs all over my place. No trespassing. $500,000 fine. If you step on this property, I don't give warning shots. I shoot one time, and that's to kill. If you put signs up like that all over your place and somebody ignores it and you kill them, there ain't nothing they can do about it. They were warned. They didn't read the sign. I'm not letting somebody come and take my children. It ain't going to happen.
Now, what if they're coming to serve a warrant or something like that, though? They may say, "Hey, we have a warrant," and that gives them us the authority to come on your property, yada 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 yada. What about a situation like that?
Then I want to see the authority that backs up the warrant. I don't just want to see the warrant. I want to see the authority. Who issued the warrant? And who authorized it, and was it done by a magistrate? Was it done under notary seal? Is it a legal bona fide warrant? If so, I'll go with them. If not, forget it.
I have to agree with you there.
The law specifically says that there's a warrant issued. It has to be done through a magistrate, and it has to be notarized, and it has to be done under penalty and perjury of the law. Every warrant that I've ever seen is never done like that. They just get a warrant by some judge that signed off on it, and they just come present you, oh, we got a warrant for your arrest. Well, prove to me it's a legal warrant, and I'll be happy to go with you.
Yeah, I have to go right with you right there. Once I started learning this and started really looking at these warrants, and search warrants too, they are so bogus. They just throw a piece of paper in your face, and you just think it's a legal document, but you're not really examining the signature. A lot of times, I've seen them, they don't even have a signature on them. Right. I've seen them where they don't have a signature on them. I'm like, where's the signature on this? I mean, there's no signature, or the signature is just a line, and there's no name under it. You can't even identify who the judge is. Say judge of court. I'm like, well, what judge? Who is the judge down there who signed this? So a lot of people, they should be aware of that and start looking at paperwork. Once you start looking at this paperwork very carefully, the fraud, and it's just ridiculous, you're going to start to laugh. I laugh sometimes. I cannot believe
the biggest thing in the country that most people deal with is a traffic ticket. When the officer gives you a traffic ticket and you take it and sign your name to it, that is an affidavit. And the officer always tells you got 30 days to report to the court. Why do you think they tell you that you got 30 days? Because the law specifically says that an affidavit, unrebutted, stands as truth in law after 30 days. So when they give you a ticket and they tell you to sign it, and they tell you got 30 days to go to court, most people say, well, I don't have to worry about this for 30 days. 30 days comes and they forget about it, and they don't go to court, and they didn't rebut it. So now, whatever is said on that ticket is, you did it, and you got to pay for it.
Now, what if you sign the ticket? Like I tell people to sign their tickets coactus specie, or, you reserve your rights under UCC 1308. What about a reservation of rights or anything? What if you qualify your signature on these particular affidavits?
Well, that helps a whole lot, but basically what I'm saying is, if you don't rebut the ticket within a 30-day period, whatever it says on that ticket stands as truth and law. Even though you reserved your rights, so what? You reserved your rights, but you still signed that ticket, and whatever it says, if you were doing 70 in a 50-mile zone, you're doing 20 over the speed limit, so now they want to charge you for speeding. So you reserved your rights. Big deal. You still owe the money, but if you rebut the ticket in writing, point for point, word for word, before the 30 days, now they have to come back with an answer to you, and they can't rebut a truth.
Now, I'm going to just be honest. Now, we got a lot of people who've been dealing with these people, right? And the public servants, a lot of them are dishonorable people. A lot of people complain about paperwork being ignored. Paperwork that gets ignored. I mean, that is the biggest thing. Now, but I understand. I do feel like a lot of it gets ignored because it's not done properly. I do think that. Because I'm just like you. I understand how you have to file that UCC 1, and then you have to do your UCC 3s off of it. I don't really, the way that you do your UCC 1 is a little different. I've heard Gene Keaton talk about all collateral belongs to the debtor, belongs to the creditor. That agricultural lien thing is very particular too, because I noticed that the United States did file a UCC 1 against the American people, and it is an agricultural lien up in the state of Maryland. So, it's very, very interesting.
You have to understand that there's only two things in this world: plants and animals. Both of them are agriculture. If you look under the Agricultural Department of Agriculture, St. Louis, Missouri, it'll plainly state that everything is agriculture. Why do you think they do everything? They loan money out under the Ag Department. If you're a human, you're an animal. If you're an animal, you're agriculture. If you're land, it's agriculture. Everything is agriculture. And so you have to understand that. So when I did my UCC, I got thinking about that. I said, why not check this box as an ag lien? And it makes a big difference. And when I file UCC papers and I take them to the court to get stamped and stuff, I always make a cover sheet. And on the cover sheet, the very first thing they're looking at is this is what I put on it. These documents must stay attached. Do not remove. Private tracking number, and I put my registered number. UCC recorded in Texas. Secured transaction registered number. Put your UCC filing number. Notice for UCC 3, 603, 604, 605. Now, if the clerk or the judge or anybody decides to remove any of these documents, they just committed a federal offense. Then when you turn all the papers over, and on the very back, this is what you'll read. Upon this notice to vacate the fraud, criminal sanctions can and will apply to you. My standing is under your oath of office that I accept. statutory law does not apply to the real man. Sign my name, put my toe print, and inside my toe print, I put my initials to my name. So when the clerk walks up and hands these papers to the judge, and the judge flips them over upside down, he's not looking at a blank piece of paper. He's looking upon this notice to vacate the fraud. And he can't say that he can't see my paperwork.
Yeah, I was about to say that is a trick that the judges like to play. They have your paperwork and have it flipped over on the back and say they can't see anything. And that's why you always make sure that you endorse the back. The back of the paper is private and the front is public. But you made an interesting thing when you said about the toe print. All right, and I've heard, I know you with your birth certificate, your feet on your birth certificate, but that's very interesting. We always put thumbprints on everything. Suppose that we
under court, when you go into court, they say, do you have standing in this court? Now, do you stand on your fingerprints? No, you stand on your feet. What's the first thing that hits that birth certificate when you're born? Your footprint. So you take your big toe and you put your toe print on that piece of paper, and inside that toe print you write your signatures, and now that gives you standing in the court. You're standing on your documents.
That's interesting. I think it's well worth a try. I'll tell you what, we got a lot of people with their hands up on the call, a lot of people on this call listening. You want to take a couple of phone calls?
Go ahead.
All right, great.
I know there's a lot of people out there that have child protective cases and where the state come and snatch your children and take your children from you. And you say, how did they do this? How can they get away with this? They get away with it because we as people have let them do it, because the government specifically says that all property, all land and all mortgages and all insurance and all people are the express property, get that, are the express property of the United States of America. So when they come and they snatch your kids away from you, and they take them down and they put them in what they call child protective services, they are actually protecting their property. They're taking their property from you for some kind of reason, and they're protecting them. But when you file a UCC and you do a property list and you claim all your children with your birth certificate and social security numbers, and you list it in your property list as your private property, you now have made a claim against your children that the government cannot overthrow. So if you file a UCC and a property list and claim your children, you can just walk into the court and say, here's my prior claim, and the judge has to give your children back to you. Simple as that.
Now, a lot of people will take some issue with that, just like I had a previous caller who called in and said, what do you do when the judge says that this is frivolous? This is all frivolous. What are you handing me this for? This has absolutely nothing to do with this case. I've had a federal judge say that to me before. What do you do in a situation like that?
Well, first of all, you cannot bring a UCC document into court unless it's certified. You go on the website, you go to the SOS Direct, and you get a certified copy of your UCC filing. And it costs you $15. They will email it to you. You print that sucker out, you attach it to your documents, and when you bring it into court, the law specifically says that no judge can adjudicate against the Uniform Commercial Code. That means they can't rule against it. If you bring your paperwork into court and you just bring it in and flop it down and you don't have it certified, the judge does not have to recognize it. It's like you don't even exist. But if you bring that paperwork in under certification, The judge is going to know you got these papers filed with the Secretary of State. Who has got the more authority? The Secretary of State, which is the third highest individual in any state, or a lowly judge sitting on a bench. Now you have authority from the third highest person in the state saying this is a certified document and that I got a claim against my children, and how are you going to rule against it?
That makes a lot of sense. Now, you said that you get it certified that they can email it to you. Now, it's my understanding that if something is certified, you have to have an original stamp. Wouldn't it be wiser to pay a visit to your UCC office and actually get that certification directly from the office, or you have like a original wet ink stamp on those documents, other than just get something off the email and print it out with a laser printer or a bubble jet printer or something like that? Couldn't that still be...
You can, but you have to understand, I live in Texas. I'm 200 miles from the state capital. And
right.
if you go into electronic filings, it will plainly state that any electronic document with a certification and seal on it will stand up in any court in the union. I mean, it's certified. It came from the Secretary of State. It's got their seal on it, got their signature of the Secretary of State's name on it. All you got to do is print it out and bring it to court.
Okay.
It's no different than going and wasting your gas and your time driving 4 hours to get there and get a piece of paper. It ain't no different than what I print out on my printer, because they're going to print it out on their printer.
All right.
Same document. But
well, now
go ahead. I have been in federal district courts, and when a judge walks into the courtroom, sits down on the bench, picks up the hammer, slams the hammer down, and says, "This is not a UCC proceeding." Now, any district court in the United States understands the UCC. They may act like they don't, but they damn sure do. And if you walk into court and you got UCC papers and they're not certified, the judge will recognize everything the opposing attorney is doing. But the judge will not recognize nothing, including your paperwork that you are doing, because you don't exist. But if you got your papers certified from the Secretary of State, now the judge has to sit up and take notice, and she give you the same standing that she gives that lawyer.
Yeah, I understand they take silent judicial notice of the fact that you really haven't made an appearance, per se, because all your evidence is hearsay, basically. And then if it's hearsay evidence, they have discretion to, hey, ignore it. They don't have to take notice of it.
My point of view, and I will never change on that, is that you never ever go to court for no kind of reason.
Right. Now this was very interesting.
And what I say is the law specifically says that you need to do your administrative paperwork prior to going to court, prior to trial date. So that means you have to do all of your paperwork, whatever you're going to present in court, you need to do it on paperwork. Keep it on the private side. Go down, turn it into the clerk of court, get a stamp on it, and never, ever show up in court. The judge cannot arrest your paperwork. What's he going to do? Take it and put it in a cell and lock it up, and he can't do nothing with it? But if you show up in court, Black's Law plainly states that a straw man is put up as surety on the bond. So when you go into court and you're standing there in your human flesh body, you are actually surety on the bond, and the judge asks you, do you understand? Look up the word understand and see what it says. Stand. You're standing under your bond. And that's what they're looking for in court in every case. I don't care what the case is. They're looking for the bond. And if you don't give them the bond, they're going to take your body as collateral and they're going to lock it up. The reason they lock it up is because the court is looking for money to pay the bills of the United States of America. They cannot get the money without your bond. If you give them the bond, they'll release your body. If you don't give them the bond, they lock your body up, and then they receive $365 a day for every day you sit in jail, and now they can pay the bills of the county. They can pay whatever they need to pay. Think of it like this. You've been in a courtroom, you see all those lush, big old oak desks and them big leather chairs and the air conditioning and all the big fancy chairs for the jury and all that stuff. Who do you think pays for that? You do. And if you don't give them your signature and let them take the money without, they're going to take your body as collateral, lock you up, and they're still going to get the money to pay for all that stuff.
Now, there's a document that I've been telling everybody to read that almost says verbatim what you said. It says creditors and their bonds. And that goes into all of that. It says exactly what you're saying, that they're going to get their money one way or another. The state is going to win, which is the point of acceptance. But now,
here's the whole thing. Everybody in America, I don't care who you are, everybody in America is a subject of the United States of America under the 14th Amendment. You are a slave to the system. And until you rebut that fact, you are one of the so-called slaves that they are going to extract money from. The whole court system is one big collection agency. They are debt collectors for the United States of America. They are there to do nothing but to collect the debt, take from your estate and put it into their estate. And if you do not understand this, when you go to court, there's only two ways to go to court. I don't ever go to court. I tell people, don't go to court. But if you're going to insist on going to court, there's only two ways to go to court: as a creditor or a debtor. If you are a creditor, you walk into court, you say, I did whatever you said I did it. I am here as the CEO, president, and executioner of my estate. I will be happy to pay the debt, whatever it is. I'll take. You just tell me what it is. I'll write you a check and take care of it right now. If you walk in there as a debtor and you argue any point, I don't care what it is, you automatically become a debtor and you are going to jail. If you don't post a bond, you're going to jail. Simple as that. All debtors go to jail. All creditors pay their bill and walk out scot-free.
That's true. Now, I read an old document, the clerk's practices, that discusses that, because that's admiralty that you're describing. In admiralty, you always have to bond the case on both sides. They used to call it a replevin bond back in the day. Basically, you have to indemnify the court, the sheriff, everybody, and indemnify yourself. It's like you're putting your money where your mouth is. It's like, okay, the public servants are all bonded. You have to bond the case as well. And because there's no money of exchange, the only thing we have is negotiable instruments that can be utilized, for the satisfaction of obligations. And as a creditor in the United States, we have this exemption that is inexhaustible. So why would you argue with them anyway? You just want to give them whatever they ask for. Am I correct?
Exactly. And most people don't understand that you can issue your own bond. There is no thing in the world that says you cannot issue your own bond. And years ago, your handshake was your bond. But now that's changed, and they want you to put up money for everything. So if you even think that you might have an issue with the court, or some kind of driver's license problem, or something with a traffic ticket or anything of the like, if you were got any sense at all, you would issue a bond. You would make up your bond on a computer, and you go down and file it in your county and get a barcode on it. And it's called a surety bond. And you put any amount of money you want on that thing. I got one filed in my county, and I got one filed with Secretary of State. If I get stopped, I don't have a driver's license. Haven't had one 7 years. But if I get stopped and they ask me for insurance or whatever, I tell them I got a bond in the county. All they got to do is call up there and find out. If I got a bond, they got no reason to arrest me. Why would they arrest me? Because they're going to have to let me out anyway.
You know, when we were talking, you mentioned this thing called a probate bond. And I went and did a little research, and I came across this website called courtbondsurety.com. And it was very interesting. I started researching it, and because, you know, when we talk about bonds, the first thing people want to know is what type of collateral do you have that is supporting this bond, and is your bond verifiable? This is like in the financial community, this is what everybody is concerned with. But I read this thing, it says a probate bond, also known as a bond of executor, administrator, trustee, personal representative, etc., guarantees that the individual appointed to manage a decedent's estate does so honestly and renders an appropriate accounting of those activities to the court. Probate bonds very rarely require collateral security other than a general indemnity agreement signed by the applicant. We ordinarily do not require that the applicant be assisted by competent counsel. I mean, this was real interesting. This is basically saying you don't need any collateral, you don't need an attorney, or anything. You just basically need your signature.
Right.
And this is what the court is saying. So, and that's a public bond, by the way. So our bonds would be considered private, right?
Right. And one of the biggest things out here is insurance for automobiles. Myself, I don't have no insurance on my car for going out and buying it through an insurance company. I don't believe in that because the law specifically says that the owner of the vehicle is responsible if there's an accident. Now, you look up in your state, I'm quite sure you'll find out it's the same everywhere, but in Texas, you do not own your vehicle. The state owns it. They issue a certificate of title. That means they authorize you permission to use that vehicle, even though you paid for it. They own it because they hold the original title. The law says the owner is responsible. If you have an accident, you send a bill to the state and tell them to pay for it. Why do you think the state requires you to have an inspection sticker on your car and a license plate and insurance? They require you to have insurance. They require you to have it because they know that they're responsible, and if you get the insurance, they don't have to worry about paying the accidental if there's an accident. But if you don't have any insurance, guess what? They're responsible because they own the vehicle. But there's another thing. You can make your own bond for insurance, and you can file it and have your own insurance for your own automobile. And that's what I've done. I've made out a $10 million policy on my vehicles. I filed it with the Secretary of State, and I filed it in the county, and I keep a copy of my vehicles. And if I get stopped and they ask me for my proof of insurance, I just show them that.
Now,
you do not need to go out here and pay $300-400 per vehicle for insurance on an automobile because it's ridiculous. You're just throwing your money away.
Especially when it's time to collect, you get in an accident and the insurance company is going all out not to pay your claim. I mean, I'm like, I've been paying these people for 3 years, and then when I finally need them, they're trying to figure out a way not to pay me.
Exactly. They'll come up with every kind of excuse not to pay.
Exactly. Or drop you You know, and then they do pay, they'll drop you right after they pay you. You know, it's just whatever. It's just, and I've always kind of thought about that. I said, you know what gives them, what makes them, more, what makes their paperwork better than mine, And the public is bankrupt. They don't have any substance whatsoever. They don't have any energy, commercial energy to do anything.
See, what I got, this is called a private surety bond, initial filing number, my UCC filing number, and my red registered mail number. Face value of the bond is $10 million. Fiduciary, Jack Lew, who is the Secretary Fiduciary of the United States Treasury. Automobile insurance bond declaration page. And then it goes down here, it has my name, and it lists all my vehicles. And then it lists the thing just like it does on an insurance policy. Claims shall be lodged against the private offset bond of the bond number and ledgered as an asset held and secured by Jack Lew, Secretary of Treasury, dated, and you put the date on there. And if there's any claim made against an accident, it is to be paid out of the United States Treasury, which is everybody in America's bank account. It's your bank. The United States Treasury is your bank. All the money in it belongs to you. You just have to know how to access it and use it.
Okay, now let's talk about, I want to get back to Child Protective Services, but then I also want to talk about this UCC filing because that was very interesting. The UCC-1, my understanding is when you file your UCC-1 and you put a birth certificate bond with the Treasury. Now, are you sending them the original long-form birth certificate to the Treasury Department? And if so, are you endorsing that? Because you're making a deposit, essentially, with the Treasury Department. You're sending this registered mail to the Treasury Department. What is your, take on that or your process, because you hear so many things on that, because that is how essentially you are accessing your account by making a claim against the birth certificate. Is that not correct?
Right. The birth certificate is already a bond. It was bond the day it was created. It's a bond. It's got a red number on it, and down in the lower left-hand corner next to the seal inside the border, it will plainly state that this is an American banknote company. And it says that it's security paper. So right there is proof that it is money. So you put any value that you want upon that birth certificate because it belongs to you. It's your birth certificate. You are the principal on the birth certificate. It actually belongs to the government because it's there, they created it. But you are the principal on it. So you put any value you want on it, you turn it over, and there's a little form that you put on the back of it that gives your name and your date of birth and your Social Security number and your account number at the Federal Reserve Bank and your Social Security, all this stuff that goes on the back of it, and you sign it, and you deposit it with the United States Treasury, along with your bond. I got a bond for $3 billion. And the birth certificate is the collateral on the bond. So I funded the United States Treasury with $3 billion with my birth certificate as collateral. So now I can use the United States Treasury, which is my bank, to pay off all my debts and bills by offsetting them. And the birth certificate is the collateral that authorizes me to do such.
Now, let me ask you.
If you do it the correct way and you file it with the right people and you send it in, I got certified copy, green cards back from the Secretary of Treasury of the United States. I got them printed out, and every time I send out a bill, I send a copy of that green card saying that the Secretary of Treasury accepted my bond. So if they accepted it, what makes you think that you don't have the authority to accept it?
Very interesting.
The United States Treasury, the head honcho, accepted my bond and didn't return it. So that means it's in the United States Treasury, and I have money up there, and I can use that money to offset my debt. So what makes you think some lowly little corporation down here What makes you think that you are not authorized to accept what I'm giving you to take care of my debt?
Okay, well, let's talk about that. Do you send copies of your paperwork to the Treasury Department too? For instance, like, I'm trying to, let's say I'm doing a mortgage, and I'm trying to offset this mortgage, and I get a payoff from the mortgage company. I accept that. I send them a bill of exchange or a promissory note or some type of negotiable instrument, and also I send them a processing instructions along with copies of my certified mail receipt from the Treasury Department and all this stuff that's been accepted by the Treasury Department. Do also notify the Secretary of Treasury also that I have let these individuals have all this paperwork, and they should be expecting to receive some type of correspondence from them to set off this debt?
No, what I do, I take the initial document that I got in the mail, and the first thing I do, I file it with the Secretary of State on my UCC-3.
Okay.
The reason I do that is because once you file something with the Secretary of State, I don't care what it is that you file, it becomes a bona fide registered security. And if anybody knows anything about securities, that means that you can go in there, and after you get a bunch of these filed with the Secretary of State, you can bundle them up and sell them to a broker and get money for them, because that's what the banks do. They bundle up a whole lot of documents, and they sell them to a broker house, and that broker house sells them to somebody else, and they sell them for like 80 or 90 cents on the dollar. So if you got a bunch of securities and they're worth, say, your mortgage on your house, your car payment, your insurance, your phone bill, your light bill, you add all that stuff up, and you got a pretty good chunk of money. So now you find a broker that's willing to bundle those things and sell them on the market, and they'll pay you for them. That's why I always register everything I got with Secretary of State, because it becomes a bona fide registered security. But as soon as I say I got a mortgage on the house, this is what I file. UC3 amendment to establish debtor acknowledged debtor has received from the secured party an asset identified as a foreign bill of exchange, stamped for the loan company, and put down the account number. The value of $3,624 dated such and such a date. Debtor is now further indebted to the secured party for the sum set of for the value of said asset, which is established as a registered security via the filing of a UCC amendment. Debtor, who is the all capital letter name on the UCC, pledges to deliver the settlement statement debtor will receive from the creditor, which is Great Lakes Education. When said asset is delivered to the creditor, Great Lakes, and the associated account, the creditor, Great Lakes, with the account number and all, is amended to reflect the receipt of said asset, the debtor pledges to deliver the original evidence of indebtedness for said account to the secured party when it is returned to the debtor from the creditor. In other words, what it's saying is that when Great Lakes sends the original wet ink signature document that I signed, the initial promissory note that I signed, sends it to the debtor, which is my all capital letter name, and the debtor deems himself insecure, so he is transmitting everything to the secured party, which is me, the human flesh, blood God created, then I'll take care of the debt. No matter what the debt is, I'll take care of it. But here's the catch. They can never, ever, ever send you a wet ink signature document because they don't have it. So if they don't have it, there's no way you can pay it. Then you have to understand, after you file that with the Secretary of State, then you put down that you're authorized to send them a negotiable instrument representing credit, because the Supreme Court law decision says that you don't have to pay with money of par because they don't have any value. So the only way that you can take care of a debt is with another commercial instrument representing credit. So therefore, you send them a commercial instrument representing credit to take care of the bill, and you file all that with Secretary of State, and then you get a printout of it, and you send it to them.
Okay. Now, wait, let me interrupt you here.
Now the ball is in their court, and they can't do nothing about it.
Okay, let me ask you a question now. I'm sure a lot of people are going to have this question now. You keep saying filing things with the Secretary of State. Yeah, now a lot of people have been having problems filing things with the Secretary of State. You know, like I'm from Texas too, where you're from, so I know what you're talking about, going down to Austin trying to do stuff. You know, it's a headache. But, you know, you go down there, the first thing they do when they hand you all this is a frivolous filing. I've got an opinion from the Attorney General. This is some of that straw man crap, yada, yada, yada. You know, what do you do to circumvent the resistance? You know, because obviously these people don't have an interest in us knowing all of this stuff, and more people are knowing. So we're running into more and more hurdles that we have to, overcome in trying to do these filings. Give me your opinion on that.
Well, I go around the country. I help people file UCCs, and I did it in several different states: Jersey, Arkansas, North Carolina, South Carolina, New Mexico, Texas, Arkansas, and Iowa, Nebraska, and Kansas. But let me say this. Each part of the country has what they call a regional office. And in Texas, it covers about 7 or 8 different states around Texas. So no matter what state you live in, you can file in the state of Texas because it's a regional office. My opinion is that Texas has the most friendliest UCC website, the most friendliest Texas website in the entire nation, because everything is done in a PDF form, it's done in a web form, and it's done in a Word form. So you can go there and get and find anything you want without a hassle. Now, on filing a UCC, if you do a hard copy and you send it to the Secretary of State, immediately they're going to give it to the State Attorney General. He's going to read it. He's going to find all kinds of things wrong with it. He's going to send it back and say, well, we can't file this because this and this and this and this. Don't worry about that. File it online. File electronically. And they will accept it if you file it the correct way. When you file a UCC-1 and a UCC-1A, most people want to just jump right in the collateral box and start putting out a whole bunch of collateral. That's not the way to do it. A UCC-1, a 1A is strictly a financial statement about you and your assets. You do not put anything in that collateral box about a lien on somebody else or all this other kind of crap that people are doing. It's a financing statement about you. So when you start out up at the top as a debtor, they will not accept the filing if you got your all capital letter name up there and down at the bottom you got your smaller cap as the secured party, because that's the same individual. You start out up there at the top, look at what it says, organization. Who is the organization? The organization is the hospital where you were born. You put down the hospital where you were born, you put down the street address and all that stuff, and you put all that stuff up there in the organization under debtor. You go down to the secured party, you put your Christian name and your address. Now you got 2 complete different entities. That's what they're looking for on the filing. On the UCC-1A in box 14, 13, and 14, where it calls for description of property, everybody just start typing in their lot and their house, where they live at, and no, that's not what it's asking for. It's asking for a description of your real estate. What is your real estate? Your estate, your birth certificate title, your driver's license title, anything that is a certificate from the state or from the government is collateral. It's your estate. You put it down. Marriage license, divorce license, driver's license, insurance, Social Security number, all that stuff. That's what they're looking for. Then over in box 15, I believe it is, 15 or 16, you put all property belonging to the debtor now belongs to the secured party. Debtor is a transmitting utility. Debtor is a trust. And down in line 7, you check ag lien. You just created a lien on yourself. And then everything else you do from then on is did on a UCC3 amendment. And you never ever go back to using the 1 for anything. The 1, everybody files a UCC1 and they jump in the collateral box and they start putting all this collateral, blah, 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 blah. No, you do it on a UCC3 and you make an assignment to whoever you're trying to do it to.
Right. And that's basically because your 1 is basically, now on your 1, you do identify that you did send a registered mail, you put your registered mail sticker that relates to your bond that you filed with the Treasury Department, right?
Right. There's I got 2 paragraphs that I stick in the collateral box that describes my birth certificate and the page number and the date that I was brought into this world and all that stuff. And then right down the bottom, you put all property belonging to the debtor now belongs to the secured party, and debtor is a transmitting utility, debtor is a trust. That's very important because everything you get in the mail comes to the debtor. So people say, well, why don't you get out of the system? I don't need to get out of the system because everything the system does, they send it to the debtor, who is my all capital letter name, and the debtor is a transmitting utility. He's transmitting that stuff and giving it to me, and therefore I can take my Social Security check and cash it every month and spend it, and I'm not in the system because the debtor transmitted it to me as a trust.
You are private, and that's all public. The public and private does not mix. You're not really in the system in the first place.
Exactly. But you have to have that UCC filed, and it has to be done the correct way. They will take a electronic filing from anybody, and they don't care what you put on it because they get $5 for each filing that you do. Now, the reason I use Texas is the fact that it costs $5 to file. Some states charge you $40 to file. Arkansas, you have to have $200 in the kitty before they'll even let you file one piece of paper. In Iowa, I think it's like $20 for the first sheet and $1 for every sheet thereafter. But each filing, it costs you like $20. In Texas, you put $100 in there and you got 20 filings, $5 a filing. And you can file as many as you want. But, every state is different on their prices that they charge. But you have to understand it's a uniform commercial code. That means it's uniform in all the United States. So why would you want to go somewhere else and pay $20 to get it done in the state you live in? You can file it in Texas for $5, and it's the same identical thing, because what you do, you go down to the county where you live at, and you put an affidavit of recording. And in the affidavit of recording, you state, I have a UCC filed in the state of Texas, and here's a list of all the documents that are filed under that UCC, and you record it in the county, and now the county is notified, and the state that you live in is notified that you have a UCC in the state of Texas.
That's interesting. Never heard of that. Affidavit of recording. That is, I like that. I like that. Because, some people, like in the state of California, a lot of people out here run into a lot of resistance in recording documents, and they're not supposed to deny you the recording of an affidavit. Am I correct? Right. Yeah, so make everything in an affidavit form, and you'll run into a lot less resistance, in attempt